Welcome to another episode on the Law Report. I hope you learned something from today's episode, so let's get right into it. Welcome to episode 75 on the Law Report. Today we are going to discuss the Vulnerable Witness Ordinance 2020, the law on vulnerable witnesses in the Turks and Caicos Islands. But before I do my usual disclaimer, this is not legal advice, should not be construed as such. For legal advice, please contact an attorney of your choice. The Vulnerable Witness Ordinance came into effect in the year 2020, and as far as I can glean from this ordinance, a vulnerable witness includes children under the age of 18 years, persons with mental disorders, persons of significant impaired intelligence and social functioning, and people with physical disability. Now, in order for a person to be qualified to give evidence in criminal proceedings as a vulnerable witness, an application must be made to the court. So let's look at Section 3 of the ordinance. And Section 3 of the ordinance states that a witness eligible for assistance on the grounds of age or vulnerability. And it states that persons under the age of 18 at the time of the hearing, if the court considers that the quality of evidence given by the witness is likely to be diminished by reason of any of the following circumstances in subsection 2, which are that the witness suffers from a mental disorder, otherwise has a significant impairment of intelligence and social functioning, or other vulnerability, that the witness has physical disability or is suffering from some physical disorder. And Section 3 describes what time of hearing means in relation to the witness. And time of hearing is the time the court falls to make the determination for the purposes of Section 6.2 in relation to the witness. We'll look at Section 6.2 shortly. In determining whether a witness falls within subsection 1b, the court shall consider any views expressed by the witness. So the witness would have a say in whether or not that witness should be deemed to be a vulnerable witness. Section 4 of the ordinance deals with witnesses who are in fear or distress about testifying. So for the purposes of the Vulnerable Witness Ordinance, a witness otherwise than the accused is eligible for assistance by virtue of this section if the court is satisfied that the quality of the evidence given by the witness is likely to be diminished by reason of fear or distress and part of the witness in connection with testifying in the proceedings. In determining whether a witness falls within Section 1, the court shall take into account the nature and alleged circumstances of the offence to which the proceedings relate, the age of the witness, such of the following matters as appear to the court to be relevant, namely the social and cultural background and ethnic origin of the witness, the domestic and employment circumstances of the witness, any religious belief or political opinions of the witness, any behavior towards the witness in part of the accused, members of the family or associates of the accused, or any other person who is likely to be an accused or a witness in the proceedings. So the law sets out very clearly what the court are to take into consideration. And if in assessing the vulnerability of the witness, the court comes to the conclusion that the witness is indeed qualified as a vulnerable witness, then the court is empowered to put in place what is called special measures. So the court could then issue a special measure direction. This will be done in circumstances where, according to section 6 of the ordinance, where a party to the proceedings make an application for the court to give a direction under this section in relation to witness in the proceedings other than the accused. So special measures does not extend to the accused, but it would appear that it could and would extend to any witness that the accused is likely to call if that witness suffers from any of the conditions set out in the ordinance. The court, of its own volition or of its own motion, can raise the issue of whether such a direction should be given or not. So the court itself, assessing the situation, even if there's not an application, the court can issue a direction. Where the court determines, subsection 2 of section 6, where the court determines a witness is eligible for assistance by virtue of section 3 or 4, whether they suffer they labor under some disability or whether they're impaired, the court shall then determine whether any of the special measures available in relation to the witness or any combination of them, in its opinion, be likely to improve the quality of evidence given by the witness. And if so, to determine which of these measures or combination of them would, in the opinion of the court, be likely to maximize, so far as practicable, the quality of evidence to be given. And the court would give a direction under this section providing for the measure and measures so determined to apply to the evidence given by the witness. Subsection 3 states that in determining for the purposes of this ordinance whether any special measure or measures would or would not be likely to improve or to maximize, so far as practicable, the quality of evidence given by the witness, the court shall consider all the circumstances of the case, including in particular any views expressed by the witness, and whether the measure or measures might tend to inhibit such evidence being effectively tested by a party to the proceedings. So, in granting or in determining whether to grant any of the measures allowed under the ordinance, the court must consider, in my view, whether the defendant could have a fair trial, whether the evidence given could properly be tested in cross-examination by the accused. Section 7 empowers the court to vary, discharge, or further vary a special measures direction if it appears to the court to be in the interest of justice to do so, and the court may do so on the application of either parties to the proceedings, or of its own volition, or of its own motion. So there you have it, the Vulnerable Witness Ordinance in a synopsis. I thank you for watching. Hope you learned something from this episode 75. Please like, share, and comment, and I will see you in another episode very shortly. Thank you for watching another video on the law report. Please like, share, comment, and most of all, thank you for taking the time out to watch this video. See you in another episode.